In business, we are confronted with both moral and legal questions. Those that choose to do the right thing are not always noticed. Those who choose to work outside the boundaries of law and ethics are well known. Welcome to BUL3130 Business Law and Ethics. Professor Thornton will be here momentarily.
I'm going to go over 12 and 15, some high points on those. I'm not going to go fully in depth into both of these in the way that I would normally, dig into them, because we're covering both chapters. You'll have a chance to kind of read through that, and we'll give you, what you need out of them, but we'll also try not to hold you too long into the the lecture here. Try not to make this as long as it could possibly be. Between the two chapters, there are over 50 slides, and I'm not going to do that to you or myself. All right, so we're going to get into chapter 12 here. This week we're talking about consideration, and we did cover this a little bit last week. So consideration is part of learning about contracts. It's the final piece to a contract. There's three legal elements of a contract: an offer, acceptance, and then consideration. The consideration is the exchange of goods between the parties. All right, so we have that exchange that's going to happen between the parties. And with that exchange, they're receiving something in it. All right. So the way that it's stated is that the exchange is something of value. All right. Legal value, something legally sufficient to be bargained for. That is consideration. All right. It's the inducement to enter into a contract according to our text, but it has legal sufficiency that it can be bargained for and fits into what we're doing. So legal sufficiency is it consists of either a detriment to the promisee or a benefit to the promisor. A legal detriment means that you're giving up something that you have a legal right to. We talked about this a little bit last week. I remember going over that. So something that you have a legal right to, and you give it up, that is a legal detriment to you. A legal benefit is obtaining something to which you did not have a prior legal right. Someone giving you something they have a legal right to in exchange for whatever you're giving over. And in most cases with contracts, especially when it's a sale of goods, we are trading money for an item, or if it's an exchange, an item for an item. But either way, each party values the item they're fixing to give to the other party. So when we have a contract for a sale of goods between two parties, we have party A, party B. Party A is holding something of value to them. Party B is holding something of value that they have. Both of those items have value to the other party also. So at the time that we enter into the contract, we have the legal right of A to hold widgets, the legal right of B to have the cash that they are going to pay for these. Once they agree to the terms, they come to that meeting of the minds, they get mutual assent. They'll then take those two items and exchange them. Now, the cash has that legal value to A, and the widgets have the legal value to B because they both now have attained a legal benefit from receiving that item. They had to have a legal detriment going into it, then they have a legal benefit. Once they receive the item, they have the benefit of now having legal right to it, which they did not have prior to that. All right, in a unilateral contract, there's only that one party. Remember, there's only one party that makes a promise. But to make the promise binding, it must be supported by consideration. They have to be willing to give something, give up a legal benefit, give up a legal right to something, and that way the contract can be completed. There's always going to need to be consideration somewhere in the mix, and in a unilateral, that consideration is still going to have to be there. Bilateral, that's both parties giving up that legal detriment. They're giving up something that is theirs that they do have a legal right to. They do not have to. They're going to give up the right to those rights to the other party in that. When we have what is called an illusory promise, that's where we begin to start looking at what is the legal sufficiency in a contract. In an illusory promise, it's a promise that does not bear an obligation on the promisor in any type, and then promise for things of the following are not considered illusory. An output contract is an agreement to sell all of one's production to a single buyer. They have an extensive amount of goods that they produce, and they're going to sell that to one person as a sole buyer. A lot of larger companies will buy components, especially in the tech industry. They'll buy components from one supplier, and they'll be their sole client as far as buying those pieces. That may be an item that they have a patent on, or something that is part of their their property that they sell and how they do it. And that single item they only have manufactured in one spot, and so they're in a contract with that manufacturer to only sell to them, and they only buy it from that manufacturer. A requirement contract is an agreement to buy all of one's needs from a single producer. The output contract is them contracting to sell only to one single buyer. A requirement contracts to buy only from that one producer. Exclusive dealing contracts, that's a franchisee or licensee by a manufacturer the sole right to sell goods in a defined market. We see those driving down the road. Most of the, especially in the local areas, most of the McDonald's, Burger King, Taco Bell, any of those places you would name, those restaurants, they're owned by a franchisee. They have a license from that company to develop that store and build it up. They pay a sum of money to McDonald's, for instance, to be able to have the golden arches on bags. McDonald's gives them the bags, gives them the cups, and those type of things that carry the McDonald's trademarks, and their franchise fee that they're paying into McDonald's covers their use of those items to be able to sell them out of that store. So it's where they have a contract that they exclusively deal with that company to have their products sold. You do not normally see a Burger King and a McDonald's operating out of the same storefront because we have a franchisee that works with just the one company in those instances. The conditional promise that can be added to a contract is a contract in which an obligations are contingent upon the occurrence of a stated event. That could be if you will refrain from smoking, you will quit smoking for a year, I'll give you $2,500 cash at the end of that year if you can prove that you've quit smoking. That could be a conditional promise. There's something of value to each person. A person who smokes, there's some value in doing that to them as far as what they perceive. But the value to the other person is them not doing it anymore, so they're willing to pay them to get them to stop doing it. Pre-existing public obligations can be the type where a person cannot enter into a certain agreement. Let you read through those. There's pre-existing contractual obligations. Also, that contract is, if it's a legally binding contract, it must take precedence over anything else that could be done. If you're already under contract with someone, trying to get them to pay you more to do the same thing, that would not be considered as consideration. You've already taken care of that in all the negotiations and everything that you did. Pre-existing contractual obligations, if it's a substituted contract, the parties agree to rescind their original contract, enter into a new one. That rescission and new contract are both supported by consideration. The same way in a settlement of liquidated debt, a payment of a lesser sum of money to discharge liquidated debt, normally done through bankruptcy or things along those lines. That's when it's not in contest. There's no disagreement about the money that's owed, that does not constitute legal sufficiency for consideration. This is, in essence, breaking a contract because there's debt and paying off what is owed. So we've now stepped away from that original contract. Settlement of an unliquidated debt, which means a debt that's still intact. That's, that would be where there's legal sufficient consideration in that one. A bargain for exchange is a mutually agreed upon exchange. When we have a negotiation that goes into the contract process, we have the bargain for exchange. If you think back to the types of proceedings we had when we were looking at alternative dispute resolutions, sometimes contract law will overlap into that area, and you may have arbitration to decide contract issues. You may have some type of mediation in there to decide a contract issue. But it's always a bargain for exchange. All right. So it's a mutually agreed upon exchange. In a setting where someone makes a offer to another party, party A makes an offer to party B, they discuss together and agree to the contract, that express contract, we see the mutually agreed upon exchange as it comes out, either spoken or written, however it may be. In an instance where, or the circumstance where we think about someone going to Walmart shopping, or someone going to a restaurant to eat, there's not really a mutually agreed upon exchange there as far as what's bargained for. We're not bargaining back and forth, but we do agree, and we both agree to exchange this. The restaurant agrees to sell a salad for your dinner for a certain amount. You agree to pay that amount to receive the salad. And so you both agree to that exchange. There just may not be a lot of bargaining going on prior to it. I don't think that Olive Garden is going to let you come in, sit down, and discuss the price of their salad with them. They're going to expect you to pay that, or find somewhere else where you can go get it cheaper if you're wanting a cheaper salad. They're probably not going to have a long discussion with you. Now, when we think about what past consideration is, an act done before the contract is made is not consideration. That's the reason that asking someone to pay for something that was done prior, when there was not any negotiation on it, does not constitute a contract, a legally binding contract. And third parties can be given consideration because they may not be part of the contract, but they are listed as a beneficiary in things such as life insurance policies, any other policy that could be given to someone else. If there's a way that, upon a certain event, the consideration is transferred to another party, then that would be a time where a third party comes into play with the what they receive. Contracts that may show up without consideration: promise to pay debt barred by the statute of limitations. A new promise by the debtor to pay a debt renews the running of the statute for a second statutory period. They are renewing that. There is a statutory limit in most states on how long a debt can be called into play if someone hasn't paid it. The reason most places will sell and write off debt is getting close to the end of the statute of limitations. They'll sell it to someone else, and then they have a brand new time of trying to recover that debt. Those companies will sell back and forth to each other. And the ones that I'm skipping over, you can always go back and look at those, doing it more for a time consideration than anything else. Here's promissory estoppel, which we had talked about. Doctrine that prohibits a party from denying their promise when the promise takes action or forbearance to their detriment reasonably based upon the promise. The reason we want to make sure that someone who receives a promise and believes that promise to the extent that it's going to be a contract is we want to protect all parties. Someone who has an undue influence over another party, they can get them to do a lot of things by their actions and make them think that they're going to receive something in return for it. If we did not have the doctrine of promissory estoppel within the court system and within contract law, we would have cases where people are being taken advantage of on a daily basis. Now, we do, but some finally decide that they need to take it to court. And when they do, all they have to do is prove that that promise was made, proven influence by the other party. The promise was made by them. That promise was reliable. It was something that had been done in the past that had tied the parties into a contract. So past actions are looked at in promissory estoppel. The influence of the parties are looked at in promissory estoppel. The way that things are promised are looked at when they discuss cases like this to see if a promise was made that should be considered a contract. Some promises are made enforceable by statute. They're gratuitous promises. They're made in a way that once they're done, they become enforceable. Modification to a contract, renunciation, or firm offers. Firm offers we talked about where that is an offer made to someone by a merchant in writing. It has to stay open for a certain amount of time and not be revoked within any amount of time. That was a quick overview of 12. Now I do want to stop sharing this one and share the next for 15. All right. And 15 is not quite as long, but it is still rather extensive. So I wanted to make sure that okay. All right. So when looking at what this one is going to be, and we should be, yeah, right here on 15. All right. So chapter 15 deals with contracts and writing and what goes into that. And I want to spend a little bit more time on this one. To see the requirements for a contract to be in writing, if you open up the PowerPoint that deals with chapter 15 and 17 are combined in the PowerPoints. If you look at these PowerPoints, Florida Statute chapter 672 covers contracts in writing. You'll find the statute of frauds within that, which is brought in from the UCC, the Uniform Commercial Code. It is part of the regulations in it, and Florida has very similar wording to what the UCC has. Now, I'm not going to take you to that, but make sure that you're looking over that to get yourself aware, make yourself aware of what the statute says. So contracts that fall within the statute of frauds. The rule is that contracts within the statute of frauds must be evidenced by a writing to be enforceable. We need a written instrument for these. So this is a contract that meets certain levels of monetary value, time in which it takes to complete the contract, to take it from executory to executed. Those things are what we're looking at for the statute of frauds. Once we meet that, we then have a point where we can no longer have an oral contract. We have to have one that is written down with signatures of the parties and the information to the contract laid out. So an express contract has to be in place with signatures from all the parties concerned. Electronic contracts and signatures do meet this requirement as long as all parties have a way to signify that they are the ones who truly made that statement and truly agree to the contract. With the statute of frauds, a suretyship provision is one where someone has agreed to pay the debts of another. The person who has done this may be a cosigner. They're not the primary to the contract for payment, but they are a secondary promisor to it. The main purpose doctrine is used if the primary object is an economic benefit to surety, the promisee or the promise is not within the statute. And if the promise is made to a debtor, it's not included in the suretyship provision either. Okay, so you want to make sure that those, if you're looking at it, and I believe there's at least one question on the upcoming quiz that deals with suretyship. All right. And an executor or administrator of an estate, there is a provision for them that applies to promises to answer personally for the duties of decedents. And then in a marriage provision, it applies to promises made in consideration of marriage, but not to mutual promises to marry. So that's a consideration of marriage. If someone is promising, if we think about how marriages were arranged at one point, and items being given to one party to make sure the marriage was sealed. That was where a lot of this came from. There are still places in the world where this takes place. But now, normally it's a mutual promise between the parties when they're getting married. Land contract provision. It applies to promises to transfer any rights, privileges, powers, or immunities in real property. That would have to be signed. A 1-year provision. This is one of the test of time. When time is looked at for how long it's going to take, if a contract is going to take more than a year to be fully performed, if it cannot be performed within that year, then we must have the signatures of the parties. In this instance, the possibility test is a criterion is whether it is possible, not likely for the agreement to be performed within a year. Then the computation of time, the year runs from the time the agreement is made. So from the point that the agreement is decided by the parties, if it's not likely, not possible that we can complete this within a year, then we need to have a contract in writing for it to be enforced on both parties in that instance. The full performance by one party makes the promise of the other party enforceable under majority view. All right. If one party fully performs everything they promised to perform, the other party is then obligated to their side of the contract. Sale of goods, and this is a low amount if you think about it for now, for what our standards are for prices now. $500 is a trip to the grocery store. A contract for the sale of goods for the price of $500 or more must be evidenced by writing or a record to be enforced. Now, if you think about this, anything over $500 that you enter into an installment plan for, you promise to pay someone in part and then the rest of it later. That would be something you would need in writing anyway. But for the instance here, just a purchase between a sale of goods between two parties, there needs to be some type of written evidence for it so that it can be held up in court. When this was created, $500 was worth more than what we would consider it now. For some of us, $500 is still a pretty good amount of money. If I go to the grocery store and walk out and I've spent $500, I feel it. And so we want to make sure that the parties are protected when they're spending that kind of money for the sale of goods. An admission in pleadings, testimony, or otherwise in court makes the contract enforceable for the quantity of goods that are admitted. Specially manufactured goods. An oral contract for specially manufactured goods is enforceable. Delivery or payment and acceptance validates the contract only for the goods that have been accepted or for which payment has been accepted. Then anything there's a modification or rescission of the contract that's within the statute of frauds. Oral contracts modifying existing contracts are unenforceable if the resulting contract is within the statute of frauds. If it stays within that, then we do not have an enforceable contract in the modification. The writing must specify the parties to the contract, the subject matter and essential terms of the contract, and be signed by the party to be charged or by their agent. All right. So you have to have the names of the parties, the subject matter and essential terms. Subject matter is what are the items, what's being exchanged. All right. Essential terms can be addresses of the parties, where delivery will take place, how delivery will take place, how acceptance must be given. Then other little things that may go into it. Is there contingencies within this for items that if one item is not available, another can be given, those type of things. So whatever needs to go in there, that is something that we've discussed, that we've talked about within our contract negotiations. Those pieces need to be a part of what we're looking at, and they need to be contained within the written part of the contract. For a sale of goods, general method of compliance for all parties, and an additional one for merchants. The writing must be sufficient to indicate that a contract has been made between the parties, be signed by the party against whom enforcement is sought or by their authorized agent, and specify the quantity of goods to be sold when we're working with sale of goods. Written confirmation between merchants, a written confirmation that is sufficient against the sender is also sufficient against the recipient, unless the recipient gives a written notice of their objection within 10 days. Now, you have to keep in mind that the contract law for sale of goods between individuals and stores and individuals is a little different than it is between merchants. So when merchants, someone who is considered a merchant under the law, when they're contracting between each other, the law changes a little bit, because we now have parties who are more accustomed to the process than someone who is coming off the street as a customer. The effect of noncompliance in the statute of frauds. Oral contract within the statute of frauds is unenforceable. It has to be in writing if it's part of the statute of frauds. The full performance, the statute does not apply to executed contracts. If a contract is real quick and it's done, we do not need that writing. So someone on the spot buying something, the only documentation they're going to need is the if there's a bill of ownership for that item, if it's a vehicle, a title, if it's land, a deed, those type of things, that would have to be exchanged. But we would not have to have anything in writing, because it is a one-time, just quick purchase. It's not something we're doing over a span of time. Restitution is available in a quasi-contract for benefits conferred in reliance on an oral contract. Under statute of frauds, if someone is relying upon what they believe to be a contract, this takes us back to promissory estoppel and things we look at there. If there was a benefit conferred that relied on some type of oral contract, that agreement, the state or the government says it is a contract, the court say it is a contract, and that quasi-contract takes effect, that the court will put the parties in, and then they will have to pay restitution for anything done that has not been completed. And of course, there's promissory estoppel again, which we have gone over. I'm not going to spend time going over it again. Parole evidence, and this is how things change. All right. So parole is when parties express a contract in writing that they intend to be the complete and final expression of their rights and duties. The evidence of their prior oral written negotiations or arguments of their contemporaneous oral agreements that vary or change the written contract are not admissible. Once you have entered into the contract, you've signed that this is a complete, and your desires to enter into this contract, this is what it's going to look like. Anything prior to that cannot alter and are not admissible when we have disputes with contracts. So once everything is said and done, we've agreed to it and we've signed off on those terms. It doesn't matter what we've said or done prior to that. The terms are now set because both parties have agreed, both parties have signed, or at least their agents have signed. There is a legally binding contract with specific terms in writing that we've agreed to, anything prior to that by the parole evidence rule means that it's not admissible. Situations though do arise where that's not applied. A contract that is not an integrated document, correction of a typographical error. Once the contract is signed, we may see an error that needs to be fixed, so that can be done. Showing that a contract was void or voidable. A written contract that's entered into, if there's a reason that contract could be voided. If it's a voidable contract, then that would be a reason that the evidence rule does not apply. Showing whether a condition has in fact occurred, and showing a subsequent mutual rescission or modification of the contract. The parties come together and agree to rescind the contract or modify it in some way, then we do not consider parole evidence in that case. All right. The supplemental evidence for parole to be considered. The course of dealing, previous conduct between the parties, practice engaged in by the trade or industry. So these are things that are customary items that are used normally for these type of things. The course of performance between the conduct between the parties concerning performance of the particular contract is considered, and then any supplemental consistent evidence when we're making decisions on this. All right. So for contract interpretation, ascertainment of the meaning of a promise or an agreement or a term of a promise or agreement. Rules of interpretation include words and conduct are interpreted in light of all circumstances and the principal purpose is given great weight. We all know there are certain words that have several different meanings depending on the context they're used and in the culture they're used in. When we think about that, we have to consider using certain words in contracts, whatever the most generalized usage of that word and the principal purpose of it, that's what the contract is going to be stating. So be careful when using certain words in contracts. Writing is interpreted as a whole, and all writings that are part of the same transaction are interpreted together. So anything that's contained in there is all put together in that lump. Language that is commonly accepted, that has a commonly accepted meaning, is interpreted in accordance with that meaning. There is a language that contract law has. And if you pull up any sample contracts online, you'll see there's a lot of fancy way of saying stuff. Heretofore and those type of words that get added into contracts. Having plain language in a contract is a way for all parties to understand. And if there's a reason for it to go to court, for it to be easier for an outcome to happen without a lot of back and forth of, well, this means this means that. The court's going to look at the most commonly accepted meaning of a word and how it's used in that case. So you want to make sure that it's something that makes sense to all parties, and the court will not see it in a way different from how the party saw it. Technical terms and words of art are given their technical meaning. So there are certain things that may have to be used if we're purchasing chips to power up an AI device. There's going to be certain technical terms involved in that are not used in any other instance, and they're going to be given whatever technical meanings they have. So making sure those are used in the proper way is very important. The manifestation of the intention of the parties as interpreted as consistent with each other and with any relevant course of performance. So if they're doing what they normally do, how they act in their intentions, that is something that is looked at when the courts are interpreting a contract. The interpretation gives a reasonable, lawful, and effective meaning to all terms. That's preferred over an interpretation that leaves a part unreasonable, lawful, or to no effect. Then specific terms and exact terms are given greater weight than general language. When you are narrowing down what terms you need, They should be tied to what the contract is for, and that will allow that to be there. Now, do not misunderstand that final line of specific terms and exact terms are given greater weight than general language to mean you have to use fancy language. That just means that being specific in what you're saying. So instead of saying in a contract that party B is going to buy widgets from party A, the more specific terms are party B is agreeing to purchase 500 widgets for a price of $2,000 from party A to be delivered on this date and this time at this location. And what other terms need to go into it being specific, not just saying that, they're going to, party B is going to pay $500 or $2,000 for 500 widgets. That tells us that there's going to be an items exchanged, and that could, as long as nothing goes off without a hitch, that's not a big problem. But in business, sometimes you do have those little hiccups, and being specific in what you're saying, the amount, who the parties are, all the pieces that go into it, where delivery is acceptable, how acceptance is acceptable, what other little pieces go into it, are there contingencies for the lack of an item, those type of things need to be considered. How are disputes going to be handled, those type of things. A contract that is a long-term style contract or one for a purchase of a large amount should include language that states how any disputes to the by the parties is handled. A lot of times those will be through arbitration. Most of the contracts that we agree to when we make an online purchase, those contracts, those sale contracts, and you are entering into a contract when you do that. When you click, I agree to these terms, you're agreeing to the terms of that sales contract. And when you agree to that, you're agreeing in a lot of instances to any disputes being handled through arbitration instead of going to court. And you are bound to that by your agreement to it. When you say you've read it, it's a good idea to have read that statement. Separately negotiated or added terms are given greater weight than standardized terms or other terms not separately negotiated. Express terms, course of performance, course of dealing, and uses of trade are weighted in that order. Expressly spelled out, this is what we're going to do, then how we do it, then what we normally do in our dealings with each other, or the usage and how it's traded. They go in order of how they're, weighted as far as what the court considers. Where a term or promise has several possible meanings, it'll be interpreted against the party who supplied the contract or the term. That's from the restatement of contract sections 201, 202, and 203. All state that. What does that mean? That if you're the person writing up the contract and you put an ambiguous term in the contract that could possibly have several different meanings, be sure that you're willing to back up the use of that by stating that it has this meaning for this contract, and that all the parties understand that it has that meaning for that contract. If it does not, then you have an issue with the contract, and someone's probably likely going to decide that they do not want to be in that contract, and it's going to balloon into a lot more than what it was. If the written provisions are inconsistent with typed or printed provisions, the written provision is given preference. Likewise, the typed provisions are given preference to printed provisions. All right. So when things go in that order, written a lot of times is going to be, that original terms. There could have been some issue when it was being typed or printed after the parties agreed. If the amount payable is set forth in both figures and words and the amounts differ, the words control the figures. All right. So be sure if you're writing out that a contract is for those widgets again, that party B is going to pay $2,000 for 500 widgets. If you have $2,000 in numbers and later on it stated that you're restating it, but you're going to write it out, make sure that you write it out in the proper way and without any issues, because they're going to look at the words, not the figures, when it comes time to interpret that contract.